Good afternoon and welcome. The LSU A&M Faculty Senate is pleased to welcome Professor David M. Rabban for our event, What Do Academic Freedom and the First Amendment Really Mean? Professor Rabban is the Dar Jamail, Randall Hage Jamail, and Robert Lee Jamail Regents Chair in Law and Distinguished Teaching Professor at the University of Texas at Austin School of Law. He served as counsel to the American Association of University Professors for several years before joining the Texas faculty in 1983. He served as general counsel of the AAUP from 1998 to 2006 and chair of its Committee on Academic Freedom and Tenure from 2006 to 2012. His teaching and research focus on free speech, higher education and the law, and American legal history. He is the author of Free Speech in Its Forgotten Years, 1870 to 1920, which received the Forkosh Prize from the Journal of the History of Ideas for the best book in intellectual history published in 1997. His many articles have appeared in Yale Law Journal, Stanford Law Review, University of Chicago Law Review, Cambridge Law Journal, and elsewhere. He was a fellow of the John Simon Guggenheim Foundation in 2016 and of the Program in Law and Public Affairs at Princeton University in 2016 to 2017. His most recent book, and the subject of his talk this afternoon, is Academic Freedom, From Professional Norm to First Amendment Right. It is a terrific book. I highly recommend you read it. And please join me in welcoming Professor David M. Rabban.
Thanks very much, Dan. I really appreciate all the work of the Executive Committee of the Faculty Senate in putting this program together. Everything's gone so smoothly. You've been wonderful hosts, and I'm delighted to have this opportunity to talk with you and then to talk about my book with the commentators later. So I'll just start right in with my talk. So in my comments today, I want to give an overview of the meaning of academic freedom as a First Amendment right. Initially recognized as an individual right of professors in the 1950s, beginning in the 1970s, the Supreme Court extended the First Amendment right of academic freedom to universities as institutions. So in a talk of 35 minutes, it's impossible to cover all the fascinating topics that I do cover in my book that are raised by the subject of academic freedom. I've chosen to focus on those topics I consider to be most important. In the discussion after my talk, I'd be happy to discuss other issues of academic freedom that you might want to pose. And, as I say, if you're interested in further delving into these issues, there's a book you can read. Okay, so somewhat surprisingly to many people, the United States Supreme Court did not recognize academic freedom as a First Amendment right until its 1915 decision in a case called Sweezy versus New Hampshire. New Hampshire state courts had held Paul Sweezy, who was a well-known Marxist economist. Maybe some economists here know his name. Monopoly Capitalism was his famous book. They held Sweezy in contempt for refusing to answer questions about the content of a guest lecture he gave at the University of New Hampshire. And he also refused to answer questions about his and his wife's activities in the Progressive Party. In reversing Sweezy's conviction for contempt of court, Chief Justice Warren's plurality opinion maintained that the state had violated his constitutionally protected, quote unquote, academic freedom and political expression, recognizing both academic freedom and political expression as rights protected by the First Amendment. In another very important decision 10 years later, called Keishian versus Board of Regents, the Supreme Court more specifically identified academic freedom as a quote unquote special concern of the First Amendment, while holding unconstitutional state laws and regulations directed at subversive advocacy. This was during the Cold War, concern about advocacy of Marxism. Subsequent cases have frequently repeated this phrase, academic freedom is a special concern of the First Amendment. But very frustratingly, these subsequent cases, and there are hundreds of them, have not elaborated how academic freedom is special. Okay? And perhaps due to this lack of clarity, decisions have reached inconsistent results in cases raising issues of academic freedom. Yet I do think it is possible to draw some meaningful conclusions from the case law, which I now intend to try to do in brief compass. Okay. In analyzing academic freedom as a First Amendment right, it is important to remember at the outset, or know if you're not familiar with this, that the First Amendment only applies to actions by the state. The First Amendment applies to state action, not to private action. So legislative and executive branches of government are state actors, as are public universities, but private universities, obviously, are not state actors. So what does this mean for academic freedom? The First Amendment right of academic freedom applies to legislative and executive actions that affect professors and universities, whether private or public, because there's state action from the legislature or executive. And state action applies to disputes between professors and administrators and trustees at public universities. But First Amendment academic freedom does not apply to disputes between professors and administrators and trustees at private universities. A professor at a private university can invoke the First Amendment right of academic freedom to challenge legislation, but not to challenge administrators or trustees. So that's a very important baseline to keep in mind. It's also important to recognize, however, that many private universities voluntarily accept for themselves the requirements that the First Amendment imposes upon public universities. If this were a law school class, I'd ask you, why do you think that might be? But since it's not, I'll pose it as a rhetorical question that I will answer, okay? Which is, in my view, that many private universities do not want to be perceived as giving fewer free speech and academic freedom rights than their counterpart public universities must provide. And to give an example from my own experience, when I was a law student at Stanford Law School, private university, the university brought dismissal charges against a professor for allegedly inciting to riot. This was during an anti-Vietnam protest. And the administration instructed the faculty committee hearing the charges to apply the First Amendment standard of incitement to unlawful activity that would have applied to the University of California, Berkeley across the bay, right? Stanford didn't want to be perceived as giving less First Amendment protection, even though it didn't have to as a pure matter of First Amendment law. So since the initial decisions recognizing academic freedom as a First Amendment right, which protected mostly teaching about Marxism from investigation and regulation by the state, this was during the Cold War, since then, many, many decisions have maintained that this right covers the content of academic speech. So to give an example from a recent case, far removed from controversies over Marxism, a court decided in 2010 that academic freedom as a First Amendment right applies to the claim of a professor of obstetrics in a public medical school that his department chair had fired him for advocating vaginal delivery instead of unnecessary cesarean procedures. And the judge said that at least where the views of a professor are well within the realm of accepted academic opinion, they should be protected by the First Amendment right of academic freedom. And this professor was protected by the First Amendment right of academic freedom. There are also many, many cases that have applied the First Amendment right of academic freedom to pedagogical decisions made by professors, protecting, however, only those that can be justified on academic grounds. Okay, beyond teaching and scholarship, courts have frequently invoked the First Amendment right of academic freedom to cover what is often called, quote unquote, intramural speech. That is speech by professors about the internal affairs of universities. For example, cases have protected a professor who claimed she was disciplined for opposing a foreign exchange program of her university. And First Amendment academic freedom was applied to protect a professor in a school of communications who argued that there weren't enough practical courses in the curriculum, that it was too theoretical. First Amendment academic freedom applied to that speech. A few cases have applied the First Amendment right of academic freedom to the extramural, right outside the university, political speech of professors. But most cases, properly in my view, as I'll elaborate soon, most cases involving extramural political speech have relied on the free speech clause of the First Amendment, not on academic freedom. I think that's important and correct. Okay, that's pretty complicated already, right? It gets worse. And I say to people, don't blame me, blame the courts. Okay, complicating analysis of academic freedom as a First Amendment right, many decisions have not referred to academic freedom in circumstances to which it clearly applies. So while academic freedom has been extensively recognized as a First Amendment right of professors, it has also been extensively ignored. Even worse, in my view, courts have often relied on other areas of First Amendment law to deny protection to academic speech that would have been provided had they applied the First Amendment law of academic freedom. Two good examples of this come from the law dealing with speech by public employees. There's a separate area of First Amendment law that covers speech by public employees. Okay, under that First Amendment law, speech by public employees is protected by the First Amendment only if it is about a matter of quote unquote public concern. Matters of private concern are outside the protection of the First Amendment. They don't have the same societal value as speech about matters of public concern, the reasoning goes. Here's the problem for academic speech. Many courts have found that academic speech by professors at public universities is unprotected because it is about a matter of private concern, not public concern. For example, matters of private concern, quote unquote, abstract theorizing. I mean, that's what professors do. Not about a matter of public concern, not protected by the First Amendment. Criticism of administrators, quote unquote, designed to make the university better, that's an internal matter within the university. It's not a matter of public concern. Okay. Claim by a professor that she was denied tenure in violation of her academic freedom, that's an employment dispute, like private matter, not a matter of public concern. So these are core areas that should be protected by First Amendment academic freedom, and that would be if First Amendment academic freedom were applied, but these claims were denied under the general law of public employee speech. There are many other cases that protect this kind of speech, but many don't. Okay, even worse than that, a fairly recent case 2006, held that speech by public employees, quote unquote, pursuant to their official duties, is not protected by the First Amendment. I was involved in that case. I could talk about it more later. I don't want to take too much time now. But I do want to point out what is already obvious, I'm sure, to you. Like, what are the official duties of professors? At the core, it's teaching and scholarship. So if this doctrine were applied to professors, right, First Amendment academic freedom would no longer exist. This doctrine would overwhelm, right, the notion of First Amendment academic freedom. The court recognized that issue in this case, thanks largely to a brief, I believe, the AUP, I know the AUP wrote the brief. I believe that brief helped the court say, even the majority said, while announcing this case, we're not sure whether this standard should apply to the teaching and scholarship of professors, but this case doesn't involve that issue, so we leave it for another day. That was almost 20 years ago, and since then, lower courts have been divided, sometimes explicitly recognizing a quote-unquote academic freedom exception to the doctrine of official duties, but sometimes applying the official duties doctrine to the speech of professors. Okay, that's the overview I wanted to give of academic freedom as a right of professors. I briefly want to give my own theory of what the First Amendment right of academic freedom should mean, kind of an approach missing from the cases themselves. And the gist of my approach that I elaborate in my book is that a convincing theory of First Amendment academic freedom must be differentiated from general First Amendment rights of free speech, while at the same time explaining why academic freedom fits within the First Amendment. If academic freedom is the same thing as free speech, there's no need for a separate theory of academic freedom as a First Amendment right. Yet academic freedom is different from free speech. Its distinctive meaning must be connected to the First Amendment. And in my opinion, the societal value of the expert academic speech of professors provides the primary basis both for differentiating academic freedom from general rights of free speech and for connecting it, academic freedom, to the widely recognized First Amendment interest in the production and dissemination of knowledge, a value that has been identified in many cases, including outside the academic context. And to elaborate the theory, and it's really based on the AUP's justification for academic freedom in the 1915 Declaration, the function of professors is to use their academic expertise to search for and disseminate knowledge, which benefits society at large. There's the crux. And professors cannot perform this function if they are subject to discipline for reaching scholarly conclusions that offend others. It does not make sense to expect professors to produce and disseminate expert knowledge and simultaneously undermine their ability to do so. That's the crux of the theory. In my view, the expertise of professors that contributes to the production and dissemination of knowledge extends beyond specialized knowledge within their academic disciplines to matters of educational policy generally. So it is therefore plausible to extend the First Amendment right of academic freedom to intramural speech about educational issues at the university. On the other hand, and this is controversial, I believe that the justification for academic freedom does not extend to speech by professors that is unrelated to their expertise, whether about university affairs or about external political issues. This non-expert expression by professors, in my view, should be governed by the same general First Amendment rights of free speech that apply equally to all public employees and all citizens. Why should professors have special rights for political expression? I don't think they should. Should they have special rights for academic issues? Yes, I do believe they should, based on their expertise and its contribution to society. So that's the crux. Okay, I will now turn to the extension of the First Amendment right of academic freedom to universities as institutions. So far we've been talking about academic freedom for professors, now for institutions. And that extension began in the 1970s. And in elaborating the meaning of institutional academic freedom, courts have often relied on a concurring opinion by Justice Frankfurter. So for you non-lawyers, right, concurring means agreeing with the majority, but with a separate justification, a separate approach. In the Sweezy case, Justice Frankfurter first warned against, quote unquote, governmental intrusion in the intellectual life of a university. That's something to be avoided in general. And then he quoted a South African statement that identified, and now I'm quoting from the South African statement that was quoted by Frankfurter, quote, the four essential freedoms of a university, which is now, this is American constitutional law now, to determine for itself on academic grounds who shall teach, what may be taught, how it shall be taught, and who may be admitted to study. Those are the four essential freedoms of institutional academic freedom. And Justice Powell's opinion in the famous Spaky affirmative action case was the first time a Supreme Court justice applied the First Amendment right of academic freedom to a university as an institution. Powell relied on the fourth of these freedoms, quote unquote, who may be admitted to study, to assert that, quote, the freedom of the university to make its own judgments as to education includes the selection of the student body. So that's how academic freedom first became an institutional right. And since Powell's opinion, which was only an opinion for himself in that case, many courts in many different contexts have relied on the First Amendment right of institutional academic freedom. For example, one Supreme Court decision applied the First Amendment right of academic freedom to a decision by a faculty committee to dismiss a student for failing to meet academic standards. So the institutional academic freedom was exercised by the faculty committee. And the court said in that case, I'm quoting now, when judges are asked to review the substance of a genuinely academic decision, they should show great respect for the faculty's judgment. An important federal district court decision held unconstitutional on general First Amendment grounds, not academic freedom, but general First Amendment grounds, a regulation of the National Institutes of Health that required grant recipients to provide advance notice to the NIH before publishing their findings, and that allowed the NIH to block publication. And the judge found those regulations unconstitutional, violated the First Amendment. And the judge in this case, very importantly, relied on the statement in a recent Supreme Court decision which allowed the government to control the speech it funds as a general rule. But that case at the end said that general rule does not apply to universities. The Supreme Court decision, quote, recognize that the university is a traditional sphere of free expression so fundamental to the functioning of our society that the government's ability to control speech within that sphere by means of conditions attached to the expenditure of government funds is restricted by the First Amendment. And according to the judge who decided the NIH case, the regulations that he found unconstitutional, quote unquote, fits snugly in the free expression at a university category that the Supreme Court carved out as an explicit exception to the general rule that the government can control speech in programs it funds. That's a very important holding. Now, as we all know, in recent years, legislatures have passed laws that have regulated the subjects and even the content of subjects taught in state universities. And these laws, I feel, implicate two of the four elements of academic freedom identified by Justice Frankfurter: what may be taught and how it shall be taught. Now, Supreme Court decisions in 1968 and 1986 addressed state regulation of the curriculum while concluding that laws violated the constitutional prohibition against an establishment of religion by government. And I want to talk just a little bit about these cases because I feel they're relevant in the current context, even though these were cases where the courts did not rely on the First Amendment right of academic freedom, but rather on freedom of religion. So it's often very interesting you can now even listen to oral arguments before the Supreme Court. So in one case was from 1968, the other was from 1984. The 1984 case arose out of Louisiana, as some of you probably know. I'll mention that in a moment. So in the 1968 case, and this arose in Arkansas, the law passed by the Arkansas legislature forbade teachers in public schools and universities from teaching the theory or doctrine that mankind ascended or descended from a lower order of animals. And the Arkansas court that first heard this case held that the law violated the First Amendment because it, quote, tends to hinder the quest for knowledge, restrict the freedom to learn, and restrain the freedom to teach. In a two-sentence opinion, the Arkansas Supreme Court reversed the lower court, holding that the state was a valid exercise of the legislative power to establish the curriculum in public schools. In oral argument before the Supreme Court, the lawyer for the state stressed this power as the main defense for the statute, while maintaining that the statute was religiously neutral. And questions from the justices during oral argument pushed how far the state was willing to assert its right to establish the curriculum. You can't get this from the written opinion, but you can see it in the oral argument. So asked if the state would defend statutes that prohibited teaching theories of racial inferiority, the lawyer for Arkansas answered that to be consistent with his argument in this case, he would have to answer yes. So then the justice asked whether the state would defend statutes making it illegal to teach geometry or theories that the earth is round. And the attorney for Arkansas retreated and acknowledged that at some point a line must be drawn that prohibiting teaching geometry or requiring teaching that the earth is flat, right, would be, according to the lawyer, unreasonable and therefore unlawful. But he said in general, courts should defer to decisions by state legislatures regulating the curriculum. In the Supreme Court's decision, it held It didn't refer to academic freedom. It just said this law was an establishment of religion. It was an establishment of a particular view of the Bible and was invalid on that ground without getting into the academic freedom issues. Okay, the Louisiana case is the last case I want to talk about in any detail. Some of you know about this law requiring balanced treatment, quote unquote, for creation science and evolution science. And in response to the charge that this law also violated the Establishment Clause, as did the Arkansas law, the state asserted that its balanced approach, right, teaching both evolution and creation science, advanced the legitimate secular purpose of promoting the academic freedom of students in learning different scientific views about the beginnings of life. The court relied on the Establishment Clause, but it briefly addressed the meaning of academic freedom while rejecting the state's defense of its law. It observed that academic freedom normally protects the freedom of teachers to make their own decisions about what to teach. And it concluded that the law, quote, actually serves to diminish academic freedom by removing the flexibility to teach evolution without also teaching creation science, even if teachers determine that such curriculum results in less effective and comprehensive scientific instruction. Yet the court also took pains to avoid the implication that, quote, a legislature could never require that scientific critiques of prevailing scientific theories be taught. If it imposes this requirement for secular educational purposes rather than for religious ones, the court indicated, the state does not violate academic freedom. Okay, there are cases denying university claims of institutional academic freedom that I think help analyze these recent restrictions by state legislatures on what can be taught in universities. And most importantly, these cases emphasized that the regulations they upheld against university claims of institutional academic freedom did not interfere with the university's right to determine the content of education, which would have been protected by institutional academic freedom. So, mandatory disclosure of confidential tenure evaluations. The University of Pennsylvania said that's protected by our institutional academic freedom. The court said no, like unanimous decision, no. You need to produce this to enforce the discrimination laws of the United States. But in reaching this conclusion, denying the institutional academic freedom claim, the court emphasized that in no way was the decision preventing the expression of academic viewpoints by professors, and that the connection between the production of confidential tenure evaluations and academic freedom was, quote unquote, extremely attenuated. There are other cases, I'll skip over them in the interest of time, cases that deny university claims of academic freedom while emphasizing that there's still protection for the content of academic speech. It seems to me, this is the final point I want to make, and it was difficult for me to reach this conclusion to some extent. I have come to the conclusion that certain state regulation, even of curriculum, is legitimate, even though it intrudes on institutional determinations of what shall be taught. And I'll use an example from my home state of Texas. Texas law requires public universities to teach a course in American history. I think that's reasonable. State university telling us, state legislature telling a state university, you must teach American history. It's not that different, it seems to me, from a state legislature saying, we're establishing an agricultural school or a medical school or a community college. That also limits what is taught and even who may be hired. But I think there's a legitimate state interest in that. But there is no legitimate state interest, in my view, in regulating the content of what can be said in those courses. You can require teaching American history, but you can't require a professor to take a particular view about American history, or tell a professor that the professor cannot express controversial views that are widely adopted within his field as academically plausible. Okay, so I just want to conclude by reiterating 3 basic points. And as I say, I'm happy to discuss these issues or other issues you may have. So first, courts have clearly recognized academic freedom as a First Amendment right of professors and universities. That is clear, in my view. But second, very frustratingly, the meaning of the right of academic freedom and the relationship of academic freedom to other free speech rights in the First Amendment remains unclear. And third and finally, in my opinion, the function of professors and universities in promoting the production and dissemination of knowledge justifies a distinctive First Amendment right of academic freedom. And at its core, not only, but at its core, this distinctive right would protect the content of academic ideas. So I'll stop with that and look forward to the comments and discussion. Thanks for your attention.